Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome to Law, Life, and Liberty with Anthony Puopolo. Anthony Puopolo II is a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he's represented clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosby, and today we're talking about understanding child support and custody in Massachusetts. Anthony will go over what really determines parenting time, how support is calculated, and what parents can expect when the court steps in. Welcome, Anthony.
Thank you, Lisa. Nice to be here. Thank you for having me.
It's our pleasure. Before we dive in, can you share a little bit about your background and what led you to focus on both family and criminal law here in Massachusetts?
Sure. It kind of happened organically. I started out of law school doing corporate law and quickly realized that I went to law school because I really wanted to be in the courtroom. I wanted to be helping people, and I wasn't getting that experience in corporate law. So I left the corporate world because I interacted with a person who was a friend who needed some help with a child custody case. I realized fairly quickly that it was an area that I excelled at, that I enjoyed, and that I really felt that there was a need for. So I started to make that a focus when I left corporate law, and then also started picking up a couple of criminal cases. And it just kind of happened organically from there. I had friends who were family law practitioners who want nothing to do with any case that has any criminal aspect to it. I would have criminal law friends who wanted nothing to do with divorce cases. So I would inherently just wind up getting the calls from those friends who say, I have this case. It has an aspect to it I don't want to have to deal with. Would you be willing to take it? And that's kind of where my practice kind of was born.
Anthony, when a parent first contacts you about divorce or separation, what do you tell them about how Massachusetts courts decide custody and parenting time?
That's a really good question. Honestly, it can be very different depending on whether or not it's a divorce situation or if it's a separation of unwed couples. In a divorce situation, there really is a presumption that it's in the best interest of the child to have as much contact with both parents as possible, relatively equal parenting time. It's not necessarily 50-50, and that's usually a much more in-depth conversation I'll have with clients about what that actually means. Unwed couples, there is a presumption in Massachusetts that the biological mother has sole legal and physical custody. Obviously, it's a rebuttable presumption. There's a lot of things that the courts will take into account to make a determination on what's in the best interest of the child. And that's kind of the conversations that we'll have when it starts. What was the nature of the relationship? If you were unwed, did you live together for how long? How old is the child? Those are all the in-depth fact gathering that I'll go into with a client when I first meet them.
You mentioned 50-50 time. What does the law actually say about that? Or is it always a case by case and they dig deeper into the history? Or is there actual law that says this is the outline for how we move forward?
Actually, that's also a really great question. It's kind of both. So it is a case by case basis. The court is always going to look at each child and what's in, because the overarching standard in the family court is what is in the best interest of the child. So we are going to look at every single case and what were the facts. Let's say we're in a divorce situation and we're starting with a presumption of 50-50. What what was each parent's role during the marriage? Do we have one person who was more involved in, you know, child sports and doctor's appointments and schools, or were both parties equally involved? There are things like domestic violence. There's actually a law that says if there is a documented history of domestic violence, it is presumed not in the best interest of the child for the battered parent to share legal or physical custody with their abuser. So there are actually laws that do say in certain situations a relatively equal parenting plan is not appropriate for the child. And I say relatively equal because even though we do say 50-50, it's the court doesn't like to put children in numeric terms. And it could be a 45-55. So we'll still consider that relatively equal. So we don't generally say 50-50, even though that's a lot of what the parents will come in assuming that that's what the standard is.
So the court makes a lot of considerations. Are there certain things that parents often overlook that make a difference in who will have custody or time with the child more?
Yes, every parent that deal with, or almost every parent that I deal with, they're very actively involved with their children. They love their kids. They want to spend time with their kids, but they don't consider, they might have had, marital work division where, let's say father took the kid to all the doctor's appointments, and even if mother was very active in discussing the child's medical needs with father, or vice versa, uh, if they're not also becoming actively involved, they look a little e- less engaged in their child's needs. Because again, when the court is a third party, we were not present throughout the entirety of the relationship between yourselves and your child. So all we can really see is the objective evidence. If we have medical records that say father or mother was at every medical appointment and we never saw the other spouse, parents are often unhappy with the result there because they say, well, I've always known what was going on. We always talked about it. But if you don't have a very in-depth investigation through something like a guardian ad litem, which is a court-appointed investigator, it may be difficult for you to be able to document to the court the level of your involvement.
Let's talk about child support. How is support calculated in Massachusetts, and what surprises people most once they see the numbers?
That's a good question. I would say what surprises people the most is just what goes into calculating child support. A lot of people don't realize they don't get credits for things like, I have a new rent to pay because I've moved out, I have more bills now. You do get a certain degree of that, but what happens is we take your gross income and it's plugged into a calculation that's redone every few years, and it gives us the number of what you owe, and it takes into account things like overtime. Any income for the purposes of child support is any amount of money that you receive that is what we call, quote, regular and determinable. So if you are a firefighter, say, and you have mandatory overtime every week, that's regular and determinable, and it can be included in your child support. Even though it is overtime, you always get it, so we can use it. Bonuses, they're handled a little differently, but that can come into child support calculations. In those cases, we use a what we call an on if, as, and when received basis. So if you receive a bonus, when you receive it, and what it is, you're going to pay the other significant other a percentage of that. And I think the biggest shock to people is really child support comes out to be about 30%, 30 to 35% of your net income. It's usually going to be anywhere from 21 to 25% of your gross. And realistically, that doesn't take into account that you're paying taxes. There are ways to kind of offset that. If you're the payor and you pay for health insurance for the child, you'll get a credit for that. If you pay for the child care for the child, you'll get a credit for that. But those are really a few of the only things that really impact the calculation. So I think people are genuinely surprised by just how much money goes into the pot and what number that creates. And it's usually a larger number than people were expecting it to be.
And then when income changes, for example, somebody loses a job or gets a raise, how easy is it to modify support or custody orders? And what's the right way to handle that?
Well, the right way to handle it absolutely is to file a modification with the court immediately, even if you have an agreement. One of the biggest mistakes I see people make is they come to an agreement with their former spouse about an adjustment to the child support amount. And then they just operate assuming that they are allowed to make that choice. But once the court's involved with your child, it's the court's decision. So you have to file it with the court and get the court to sign off on it, because if you don't, then the ultimate, let's say you had a $200 a week support amount, and you and your former spouse say, I can't afford that anymore, let's drop it down to 150, and you think that you're good just because you had an agreement with the other person. 6 months later, that person says, I changed my mind, I don't like that. You are technically in contempt of court because you didn't get the court to sign off on it. So the first most important thing is file a complaint for modification. If you have an agreement, there's a form for a joint complaint for modification. Get the court to sign off on it. As far as how easy it is to adjust, it largely depends on what happened originally in your separation. So the standard to modify child support in the Commonwealth of Massachusetts is what we call inconsistency with guidelines. Essentially, if the amount of money that should be paid in child support is different than what it was previously ordered, then there is a presumption that it needs to be changed. That said, let's say when you separated, the guideline said $300 a week, and you and your former spouse mutually agreed, we'll just do $225. That's what we call a deviation, because you mutually agreed not to follow the guidelines. And if the court accepted that and said, we're going to accept that you have deviated from the guidelines, your standard is a little higher then, because now you need a material change in circumstances. Losing a job obviously would be material. Just getting a raise and wanting the other person to have to pay more may not be, because people generally expect that if they continue to do well in their job and continue to work at the same place, they will get raises. So if you've deviated in the past, it may become harder to get a change in the future.
Interesting. Boy, you need to stay up on these things and don't go it on your own. Reach out to your attorney and confirm. For parents just starting this process and feeling anxious about losing time with their kids, what's the most important thing they can do early on to protect their relationship and keep things civil?
The most important thing, I think, to keep things civil is to have a conversation. If you are at a point where you can still have a civil conversation with your significant other, have the conversation that this is all about what is best for your child. Because a lot of people can really get caught up and forget, at the end of the day, you both love your kid. You both want what's best for your child, and you don't want to spend your child's college education on lawyers fighting over your child. Have a conversation, and also be reasonable with yourself. Part of my job as a family law practitioner is to not only fight for my client, but to try to help my clients understand what they should reasonably expect. If I have a client who worked 80 hours a week throughout the course of the child's life, maybe saw the child on the weekends, who then comes to me and says, I want 50-50 or relatively equal parenting time. I want 1 week with my child. My significant other can have another week with my child. The court is not likely going to do that. The court is likely going to keep whatever the schedule is that the child is used to. So trying to keep things civil and not going off the rails, so to speak, it is important to be honest, not only honest with your significant other about what everyone's goals should be, but also be honest with yourself.
Thank you, Anthony. That's it for today's episode of Law, Life, and Liberty with Anthony Puopolo. To learn more about Anthony and his work across Massachusetts family and criminal courts, visit agplawoffices.com. Thanks for listening, and don't forget to subscribe, share, and leave a review so more Massachusetts families can find the guidance they need.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.